Good afternoon, everyone. Welcome to tonight's TMA webcast with our local bankruptcy judges. Tonight's topic is the new reality for 2020 in the bankruptcy court and 2021 expectations for bankruptcy court professionals. Again, I'm Jack Teets. I'm with Compass Advisory Partners here in Pittsburgh. Before we get started, we would like to thank the TMA annual sponsors for the Pittsburgh chapter. Their generosity during these challenging times helps to ensure that we can continue to provide valuable programs to the TMA members. The screen has the logos of most all of the members and sponsors. More importantly, we want to thank each of our judges for making themselves available for this evening's program. Unfortunately, this year we're not able to do it in person, but our judges were still willing to stay involved with the TMA and bankruptcy practitioners, and we thank them for their time this evening. On this evening's program, I'd like to introduce our four judges who will be participating tonight. Representing the United States Bankruptcy Court for the Western District of Pennsylvania, the Honorable Carlotta Bohm, the Honorable Jeffrey Deller, the Honorable Greg Tedonio. Judge Tedonio will be arriving on the screen at 6 o'clock due to another matter that was going to tie him up here at 5:30. And a special welcome to our newest judge from the U.S. Bankruptcy Court in the Northern District of West Virginia, the Honorable David Bissett. Again, thank you to all of the judges for participating in this evening's program. In terms of background, the judges are more than capable of introducing themselves to all of the attendees and participants. So I'm not going to spend a whole lot of time with that process. Again, to most of the people who are here and have joined this webinar, the judges are fairly well known. In terms of the program content, those of you who have done this in prior years when we've done it live, we've been able to take questions from the audience at any point in time. We will continue to do that this evening through use of the chat function and the Q&A function. So if you do have a particular question that you want to forward to the group as a whole or to a specific judge, please use the Q&A function and it will forward it to me and I will be able to direct your question. As is our standard policy, if there's any questions or comments about any specific cases, those don't count. Just you can send them, but I won't ask them, and we'll keep this all moving forward. The other disadvantage of doing this in a web Zoom-based function is we don't have the collegiality and the ability to laugh at each other collectively that we have when we're all in person. So to the extent that you get some oddball comment from me, it's designed to make people laugh wherever the hell they happen to be participating in this program this evening.
Hey, Jack.
Judge?
I am actually recreating the mood of the Duquesne Club or wherever we usually have this. I have my beverage and I finished my macaroon already. So I'm doing my best to recreate it.
Now, wait a minute, Deller. You know, Jack always gives us like a little bag of macaroons. Where are those?
That's right.
Well,
He sends us home with those macaroons.
we're going to have to do that once the Duquesne Club opens up to having more than 4 people at a time. I happened to stop over there today and I had a macaroon. So unfortunately, they're still making them and they're still dipping half of them in chocolate. Judge Bissett, we're going to have you join us, when we do that, because it is worth the experience of a Duquesne Club macaroon, but more importantly, it's a good time to laugh and rub elbows. But without any further, thank you. Without any further delay in the program, one of the things that I'd ask the judges to think about commenting on is how the whole COVID situation has affected the ability to continue to operate the bankruptcy court. And more importantly, not only what's happened in the past, but as we move forward into 2021, what should the bankruptcy practitioners be expecting in terms of how you folks intend to conduct, court hearings, testimony, etc. And again, I'm not in any particular order. Judge Deller, if you'd like to go first, I'll try to move the questions around in terms of who goes first. But if you could comment on that a little bit, and when you're finished, we'll move on to Judge Bohm and Judge Bissett.
I'm happy to comment on it, but I would like to really defer to Chief Judge Bohm and to give her an immediate shout out. You know, this whole COVID situation came along under her watch here, and she has been the steady hand guiding our bankruptcy court, making sure that not only the judges, but also the clerk's office and the bar have ready access, you know, to the court so that the wheels of justice don't fall off. And it has been a seamless endeavor on both, you know, having hearings. I've had 2 trials virtually, no problem at all. And but I'd like to defer to Judge Bohm, you know, with that question, because really it's been under her watch, under her laboring oar, and you know, she's just done a tremendous job during these difficult times.
Thank you. That's very nice. Extremely nice. I wasn't expecting it. There was no need. But we have been acting, we moved out of basically the US Steel building and even in Erie on March 17th. And everybody has been operating virtually. The court is open, guards are there. People can come in and file. So we are totally open, but everybody's working from home. We have not skipped a beat. I'll give you statistics in a few minutes, but nothing has been delayed. All orders are entered. We've been constantly involved with the Bar Association, going to the Bars Association meetings. We've had my involvement and the clerk going and on a monthly basis to talk to the bar so that if there's any disputes as to any problems with them, we can deal with them. We have had not one complaint. We have had no problems. Each judge's chambers answers the phone all day. We have people dropping into the court to pick up papers if we have to. I don't see us going back too soon. Trials are being arranged and conducted, as Judge Steller told you. I haven't had one. It seems that 3 that I've scheduled have been continued each time. So they haven't occurred on Zoom, but I'm ready to go and I'm looking forward to it. I'm conducting all my hearings starting 100% with Zoom in December 1st. So far, we've been doing half the hearings on Zoom and half on court call. One of the reasons I split them up like that was because my staff hadn't come up to par and weren't that comfortable with Zoom. And I wanted to move the motion stays fast through my docket. But everybody's up to operating totally through Zoom. The Bar Association seems to be very pleased with the way Zoom is working and court calls. So there's been no issues for us. We will continue operating like this. We will see how the pandemic affects the whole operation. That we have protocols that we've set up if we have to go partially back, if we're going to hold in court hearings. Our clerk is very involved in working with the district court, the Third Circuit, and nationally in all the protocols that would have to be in place. But my position as chief judge is that nobody should be put at risk. There's no need when we can operate so well through Zoom or court call. I'm going to give you a statistic. We had 1,631 hearings from March 17th until the end of October. I'm sorry, through March 1st through the end of October. Of those, there were 358 Zoom hearings. We had scheduled 7,306 hearings, but we defaulted about 5,300 matters. Chapter 11s are moving well through the system. So we're not seeing any problems. We are prepared to take whatever moves we have to. And since we're operating so well out of the office, we'll continue doing so.
And if I could add, you know, I know Judge Agresti's having all of his hearings by way of Zoom right now. I believe Judge Tedonio, either he is or he's in a hybrid. He is.
Yes.
And so with Judge Bohm going to a lot more Zoom beginning in December, I'm going to be going to all Zoom virtually all the time beginning in January. And that's because I'm training all of my staff so that everyone can be, you know, what does Mike Tomlin say? Positional flexibility, so that, you know, every member of my staff is adequately trained so we have no hiccups. You know, I've done most of my hearings to date through use of court call, but I have had 2 full-blown trials, you know, more than just, maybe someone referencing a document. I mean, I've had instances where, these were all day trials, essentially, taking testimony, having documents admitted into evidence, and, occasional hiccup on Zoom. As we see, sometimes it freezes every now and then, but we get past that, and it has worked. It has worked really well.
Judge Bissett, comments on what you're doing in your court and how it's going?
Yes, and first of all, let me take the opportunity to thank the TMA for the invitation today to participate. For those of you that do not know me, which I imagine there's quite a bit on the call today, my name is Judge David Bissett. I'm recently appointed to the bench in March of this year after retiring. Judge Pat Flatley retired. And my history is I come from the U.S. Trustee's Office with that program for over 16 years before coming to the bench. And I surely defer to the expertise of the judges that are on the panel today. And I'm sure a lot of the areas that we will speak about. And I certainly, one of the reasons I wanted to participate was certainly to meet the participants as well as the panel, distinguished panel I believe we have today. For people to hear from. With regard to the question, we're U.S. In the Northern District are operating very similar to the extent that I am the only judge in the Northern District of West Virginia. Similarly, in the Southern District of West Virginia, we have a brand new judge as well, Judge McNault, who I believe has been on the bench for a month. So West Virginia has been in some transition, as you can imagine. I'm sure the bar would express that as well. But I think that at least from the Northern District perspective, that we have jumped in and have handled very similarly to how Judge Flatley was handling things. Fortunately for us, before the pandemic, a lot of the hearings were handled by telephone. So the court was used to that concept, and we've carried that through, particularly for Chapter 13 matters. In fact, all of our dockets for 13 matters have been handled through the telephone. And I have found it to be an excellent process, because what I was concerned about was how the bar would work together in order to resolve issues. And in fact, what I found is that this process has maybe made that more easy for practitioners, to the extent that they, in fact, are meeting with the Chapter 13 trustee prior to the hearings, maybe more so than they were before. And a lot of the issues have been streamlined. For other matters, Chapter 11 matters, as most of you probably aware, we do not have the numbers that I'm sure are in Pittsburgh, but for the Chapter 11 cases that we do have, we're attempting to process those through phone, and we are using Zoom as well. We tested a couple systems before, Cisco or Zoom, and have found, as I think other courts have found, that Zoom appears to be the best platform. I will say from our perspective, at least from my learning, that we've had a couple proceedings on Zoom, and what I found to be the case is, again, as I'm sure the other judges would indicate, that part of the key to a good process is the attorneys that are involved in that process, and a good pretrial order with regard to exchange of exhibits and information before the Zoom goes through. We require the parties to do a test of Zoom before the hearing, as well as exchange exhibits and present a pretty clear pretrial order so that the parties are on the same page. And from my experience, that is probably one of the key components with regard to Zoom. But I haven't had anybody kick about doing it. And I think that the parties, for the most part, have been very cooperative, with the understanding that they don't want to expose themselves. We have done some in-person matters, but it's been rare and limited to matters that at least I have felt have been too complicated for Zoom. But I would echo the comments of the judges that I think from our court's perspective, we're at work, we're processing cases, and I think that we're doing so in a quick manner at this point.
Thank you. As a follow-up, in terms of your expectations, do you think that the Zoom process will continue through the first 6 months of 2021? Based on all of the medical advice and all of the practices that people are, working under. Do you think it may go longer than that? I mean, that's more of a COVID question, but as an observer of the process, one of the things that in conducting many meetings in the last 6 months that are more business meetings than judicial proceedings is oftentimes there's some degree of confusion of what documents people are looking at and what they are referring to. To the point I've got people holding up documents on the screen so everybody can kind of get, to the same place at the same time. And it does seem to me it takes longer. It takes longer for people to express, their position. And it seems to take longer to have group interaction to get, some degree of buy-in or agreement. I don't know if you'd care to take a couple more minutes and comment on those comments or not.
Well, a
I'll be
couple
glad to
things.
address that. Go ahead.
Yep. Ladies
ahead.
first. Ladies
All right.
first.
First of all, I really do think that we're going to be virtual until June or so. It may be longer. And since it's working so well, probably motions and certain things could absolutely continue on Zoom. Now, we'll get into issues with trials. I agree with you. It's much harder to look at exhibits and do things on the screen. So what I was planning to do, my 3 trials that canceled, is have them deliver exhibit binders still, just like we normally do when we have a trial. So I would have a binder. Usually I have my law clerk has a binder. We would each be in our homes, of course, and the lawyers would have it either on the video and also deliver the paper if we have to. I just recently got a case where there's like 900 documents. How could we possibly 900 pages look at that easily as you're presenting them? So I think we're going to have to be a little bit flexible if we have a really big matter that we need to be maybe in person. And I've thought about that. If that happens, maybe I'll go in the courtroom and maybe have you, Jack, there and 2 other lawyers, the minimum amount of people, and the rest would be on Zoom, so we protect the public. But if we have a big enough matter that we can't handle, from our offices away from the courthouse, then we'll have to work around it.
Okay. Judge Deller?
Couple things. I think the question is maybe it's multi-part. One deals with timing and use of this remote technology, and the answer there goes into whether use is continued based upon COVID versus non-COVID. Well, COVID is really out of necessity as opposed to perhaps discretionary. Just looking at the timing of COVID, the pandemic is still here. If we are fortunate enough to have a vaccine, before the end of the year, well, it's going to take time to administer that vaccine. So best case scenario, we get a vaccine before the end of the year. Well, it's going to take 3 months or longer to not only have manufacturing, but also distribution of it. And then you have a time period for the vaccine to get out to the general public, which again, best case scenario is another 3 to 6 months. So a realistic, pragmatic view of it is we could be in this virtual environment for best case scenario, another 9 months or so. Again, I'm no scientist, but I'm going by everything that I read. From a discretionary standpoint, the video has worked better than anticipated. And, looking at the efficiencies of what we do, I mean, look at the Chapter 7 process, for example. Bankruptcy trustees get these cases in a no asset case. They're only making 50, 60 bucks. Well, why not encourage them to use Zoom in order to have their examination? It'll cut down the expenses there. Maybe status conferences in cases, again, it saves travel time and expense for the bar. So maybe utilizing Zoom and those types of things. Your concern about some logistical problems, a big case with a lot of documents. How I've handled that is we've had the lawyers download the documents prior to the evidentiary hearing. I've had my law clerk be the document control person, and and counsel essentially during the trial asked the clerk to put on the screen.
Sure.
Exhibit 1, page 7, and so that way we have control of the document. Everyone's looking at the same thing. There's no question about what's being used, and that's actually worked. It does. right? That way lawyers can be lawyers. But from a discretionary standpoint, once the pandemic is over, I see us increasing the use of the courtroom though. We're not going to be virtual all the time. I think it's important to have things in person because, again, the bankruptcy court is a federal court and these proceedings are serious. The fresh start is serious. The rights of creditors are serious. And being in a courtroom with a real judge looking at you in the eye and you looking at the judge in the eye, I think is very important. And that's not going to go away.
Thank you, Judge Bissett.
Yeah, and I agree with all those comments, and I can say from my experience that even the limited in-person hearings that we have done in compliance with our chief district judge's orders on COVID compliance in the courthouse itself, the matters are slow. One of the things that we've had to deal with is wipe down procedures if an attorney where we limited the parties to the attorneys and or necessary witnesses, but spatial distancing, as well as requiring the attorneys once they're done to wipe the microphones and that just even in the in-person scenario slows down the process. So I guess it is a new world. And I can say that as a new judge, I don't know if this is a good thing that things are slowed down or if it's a harder process, but I will say that it is frustrating from a judge's perspective. I think as judges, we lose a lot of perspective from the video side of it. Certainly, that's one of my concerns that, it's very one-sided, and I think we don't have the advantage of seeing the parties in the courtroom. Particularly, at least that's my experience with the phone calls. That's something I personally miss, and I think it does make our job a little bit more difficult. To Judge Deller's point too, is at least to my knowledge, U.S. trustee is still, at least in West Virginia, is doing meeting creditors by telephone. So in a lot of these cases, it's possible that debtors will never see a live person in a bankruptcy case. So, I think there is an important component to debtors to recognize that it is just not a process that you fill papers out and you never have to do anything else. But it's really changed the landscape in a lot of different ways. But I think my experience has been that the court is dealing with it the best way it can.
Again, thank you for those perspectives. One of the things that I think is probably missing from folks who are participating in this webinar, most of the attorneys that I've had the good fortune to work with, I think they all view themselves to some degree as showmen as well. So I think that you probably are seeing, as judges, seeing less of that in the video than you're used to seeing in the courtroom itself. So I think that takes away from some of what they view as their skill set and their attributes in trying to, present their clients' perspectives and opinions. So that's just another observation that I have relative to the practice group that is in front of you judges, on a day-to-day basis, who are now faces on a screen. So let's shift to a little bit of the other legal developments within the bankruptcy arena in 2020. Again, this is now where it starts to get, I can read the questions and I can listen to the answers, but it's for the bankruptcy practitioners that are out there. I understand there was a third circuit opinion with a new cram down test, I guess, related to the Tribune case in Philadelphia. I don't know what the real world implications of that ruling happen to be, but I thought it would be a good topic to discuss with the audience this evening. Judge Bissett, I don't know that it necessarily applies because you're in the other district, but nonetheless, I'm sure you're aware of, what the ruling was. Would you like to offer a few comments?
Well, I am aware I've read the decision. And again, as I proffered before I started, I have not seen it in application yet for a number of reasons. Really, I have currently probably 3 Chapter 11s pending in front of me. And that's partially because when I did come on the bench, I did have a blanket bar for hearing any Chapter 11 matters because of my association with U.S. Trustee's office. And So I've had limited exposure to Chapter 13 or Chapter 11 context to see it in use. And so I would probably defer to either Judge Bohm or Judge Deller with regard to that question, but I would like to hear what their response to be if they've seen it yet, at least that applied in the Chapter 11 context.
Biggest,
Judge Bohm? Judge Deller, go ahead.
well, the biggest issue we have really is, is the number of cases, and is it really going to have a trickle down effect? I don't know if it's going to have a trickle down effect or not, either positively or negatively. I looked right before I dialed in. I decided to have a look at my docket and see how many Chapter 11 cases have been assigned to me in the past year. So this is both pre-COVID and during COVID, and there are only 11 Chapter 11s on my docket. 7 of them come out of the Johnstown division, 4 out of the Pittsburgh. And, extrapolating that across 4 judges, we're talking only maybe 50 Chapter 11s in the past.
I can give you the number. It's 43.
43. And so the number 11s is down tremendously. Usually we're between 80 and 100 every year. And I don't know whether you get any comments from the bar or the turnaround professionals. My question to them is, in light of the economic times that we have, where are the 11s? And why aren't they being filed? Is it a structural issue? In other words, they don't have access to capital or liquidity to fund the 11. Is it a situation where, with the moratoriums issued by the governor and the CDC, is that preventing a push into bankruptcy? I'm just really curious as to why they're not being filed. And I don't think our experience in the Western District of Pennsylvania is any different than other jurisdictions. Yeah, big cases get filed in Delaware, in the Southern District of New York, and down in the South. But there's a lot of mom and pop businesses out of there that are struggling under this environment. And why haven't they filed?
Judge Bohm, if you want to comment, otherwise I'll start to fill
Well,
in here.
you can. I was just going to say that we're surprised because last year there were 49 Chapter 11s, and this year there's only 43. And we've only had this subchapter 5s, 10 of those. It's really a limited number that's coming down. Now, the bankruptcy filings nationally, as you sent out, Jack, were 21% down in the filings. We seem to be in the middle of the country as to rank where we are as to the drop. I don't know why we haven't had a large amount of filings. Now, the 11s are an issue, but there's a really downtrend too in filing Chapter 13s. And that shocks me too, because where are we with the economy? All these jobs that have been lost, all these people that haven't received income and running up their debts. So I do think that the moratorium on the foreclosures and collection probably has dropped the numbers, but that shouldn't have dropped the Chapter 11s at all.
I'll give you a little bit of my perspective from the view of Compass and our clientele and our interaction, again, with the lender community and with the bankruptcy legal community. I attribute it almost entirely to the availability of the PPP funding. There was a significant influx of money made available to the small businesses, the medium-sized businesses, to a lesser extent, larger businesses. But when that money started to become available in April, May, and June, it really helped to buffer, if you will, what were going to otherwise be very hard economic challenges and liquidity challenges that these companies were facing. And I continue to be intrigued by the fact that there haven't been filings, but I think that infusion of new liquidity in the form of those PPP monies is what contributed in a very large way to a deferral of the bankruptcies. I think coming, in the end of the first quarter, second, third quarter of 2021, that money will have run out. The recoveries of these businesses will have stalled out to some extent. And I think that there will be an increase in the number of cases, the Chapter 11 cases, particularly, the small and medium, the middle market kinds of businesses that you traditionally see filing cases here, in the Western Pennsylvania district. And I assume in the Northern District of West Virginia, you'll have similar comparable kinds of increases in the coming year.
Well, have you seen an increase? I haven't talked to Judge Ward, but in the receiverships and those movement in state court?
No. I think overall, the PPP money coupled with, I think, the lenders have also tried to be more accommodating for the time being. So again, I think that will change over time, but everybody's mutual desire to not have the impact of COVID inflict additional, economic damage on a particular, company or groups of companies, I think has been something that has had a good impact or has been effective in delaying some of the businesses that have struggled. I think that there will be a significant increase in the filings, and they may just go right to Chapter 7 of the restaurant community and some of the hospitality community. I think that the hotel, motel, industry is in really, there's some deep challenges there. Everybody's aware of the restaurants that have continued to close, and the ones that are open continue to struggle. And if that doesn't start to improve, again, in the next 90 or 120 days, I think that you'll see, a huge increase in the number of filings. Then some of it may become they go right to Chapter 7 because there isn't any economic substance left to be able to support, some type of reorganization.
Right, I agree. I think you're going to get an influx of Chapter 7, especially for restaurants, bars, places that have minimum assets.
Yeah.
Jack, a couple of things. One is you started off with that Third Circuit case. The greatest impact or a potential great impact that Third Circuit case might have on it will be Chapter 13s, because there hasn't been an articulated test for what is fair discrimination or the classification of claims. I think that'll be ripe for litigation in the future. Back to the PPP point, the Paycheck Protection Plan. One of the things that I was keeping my eye out on the docket, and I think other judges around the country, were instances where the Small Business Administration or wherever you get these paycheck protection loans, the extent to which borrowers were being declined access to them because they were already in a Chapter 11 proceeding. Have you seen much of that out there?
Early on, I think there was a prohibition that if you were in a chapter case, you could not get the PPP money. There was a reformulation of the regulations, and I think that they did make some provision and allowance for that to happen. But I think what you're going to see is people that have the PPP money filing the bankruptcy cases, in 2021. Again, that money comes basically through the lenders and is guaranteed by the SBA. And I think because it's so new, because the regulatory announcements continue to be changing, that there's still, some loose ground there in terms of what's really going to be the impact. But, we've had a number of businesses that we've worked with that have been able to get, anywhere from $100,000 to $2 million to help support primarily payroll. And, it's kept people employed, and to the Chapter 13 issue, I think that has also, allowed people to survive during these very challenging times. If we could shift gears for a few minutes and talk about the Small Business Reorganization Act in Subchapter 5. Judge Tedonio was telling me a week or so ago that he has been spending a significant amount of time looking at that and trying to develop some local rules in conjunction with the practicing attorneys. He also told me he would be joining at 6 o'clock, which he has not chosen to be able to do yet. So we'll start the conversation and we'll push some of it off on him when he shows up.
Well, Jack, I have some information. And that is, I've only had one subchapter 5 case. But I would give you a summary how it went. And that is, it was filed on February 21st. It was a mom and pop business that had about $750,000 a year in revenue, so a very small business. Tax case, $200,000 of claims from the IRS and the Commonwealth, and general unsecureds. So case was filed on February 21st. Schedules were filed on March 13th. Counsel didn't file his retention application until March 27th. So cautionary tale there for folks who are looking to dabble in Chapter 11. Please get your retention applications filed sooner. The plan was filed on June 29th, which was 127 days after the petition date and 40 days after the 90-day period provided in the statute. Does permit the court to extend the time to file a plan if there are circumstances for which the debtor is held accountable. And so I provided the debtor with, I would say, a COVID courtesy there and extended the time. Amendments to the plan were filed and ultimately it was confirmed on October 29th. And no litigation took place. And the attorney's fees in the case were $14,000. Trustee compensation is $6,800 in the case, payable over the 60-month life of the plan. So in and out pretty fast. Counsel fees, $14,000, not much. Trustee fees, $6,800, not much. Pretty efficient.
All right. And again, we've not participated in any of those cases thus far. We've had some smaller businesses reach out and talk to us about the relative pros and cons of proceeding that direction. I do expect that we will be involved in some of those cases in 2021. Judge Bohm?
Yeah, as I indicated, there's been 10 in our district. There's about, Judge Deller's the only one that had one confirmed. I've got 2 very active ones, which I think will have consensual plans. They have large amount of income running through them. So I think they may be able to work with the trustee. I think it's interesting, the role of the trustee. I was a Chapter 11 and Chapter 7 trustee for a long time. And this trustee is not really a trustee. The powers, as we looked at them, are not the powers that were involved in the Chapter 7 or 11 mode of a trustee. It's more like a Chapter 13 trustee. And the trustee is to take a very active role with the lawyers trying to work out a consensual plan. There's no creditors committee, which is interesting too. I think some of the elements are good. We'll see how it works, but I don't know in our district how much the lawyers are looking at filing these subchapter 5s. I'm just surprised we don't have that many. It sounds like there's quite a few in New Jersey. The Eastern District of Pennsylvania was having quite a few files last time I talked to one of the judges there. But across the country, there haven't been many. 1,000 is not that many. So
I think they're not that many because there's a fear of losing control.
Well, and I think you are, and that's another problem. I used to be Chapter 11 practitioner. I don't know that I would want to lose too much control and have a trustee there, but it's not a traditional trustee. They're not taking over operations. They're not touching your income. I mean, it really is a hybrid.
But I think through time and once folks realize that, it's kind of like going swimming, put your little toe in it. It's cold. You don't want to jump in, but gosh, after you jump in, you realize it's not that bad. But again, it's through custom. It's through people being familiar with the process and the limitations on the subchapter 5 trustee and the fact that the debtor is still a quasi debtor in possession. I think they'll get comfortable over time.
I think there's going to be helpful that you don't have to follow the absolute priority rule. There's a lot of benefits for debtors. So they may start filing. I agree. I think they got to get used to it. They can be moved fast through the system. Like I said, I'm very hopeful. The ones that are in front of me, they look like they're likely to work. So.
Judge Bassett?
Yeah, similar experience. I have one, and to my knowledge, in West Virginia as a whole, we've had probably, I know, under 10. West Virginia has two subchapter 5 trustees. Both of them are accountants, non-lawyers, and I know, based on my prior experience with U.S. trustee, is that both judges have pointed out that certainly the U.S. trustee selection of those trustees was exactly to the point the judges made, was not as your cookie cutter Chapter 11 trustee or Chapter 7 trustee, and why they didn't pull from those panels. They were looking for individuals that had maybe more practical experience, and I would characterize it more as a mediator. I think that the use will become more popular for some of the advantages that have been pointed out. One of the things that I at least have a concern about is the fees, and particularly for the subchapter 5 trustees, of how they're going to get paid. I think that they take a big risk in these cases and how they progress. And at least the limited amount I've seen so far, that there's not a whole lot of discussion of what involvement, in a non-consensual plan, perhaps, of how the trustee, as I understand the requirements, will have to be involved for potentially up to 5 years, and how they're going to get paid. And then they're taking a risk, during that month period, of how much time they put into the case, because, as we all know, a lot of these small business cases don't have the income stream to support a large administrative fees from counsel and from any other experts that come into the case. So I think that that's going to be a big factor, and how much those subchapter 5 trustees come experienced in that process, and how much they almost work with debtors counsel, I think is going to be kind of a pre-indicator of how successful subchapter 5 will be. So that's what I'm looking for too.
Judge Bissett, let me ask you this question. One of the complaints that I've heard through the 15 years I've been a bankruptcy judge from Chapter 7 trustees is the onerous reporting requirements and oversight by the U.S. Trustee's Office. And that's not a criticism. I mean, I can appreciate the U.S. Trustee's Office being the watchdog. And the reason why I'm asking you this question is you used to be an attorney for the U.S. Trustee's Office, and now you're a bankruptcy judge. Do you think the reporting, it will dissuades folks from wanting to be a subchapter 5 trustee, or do you not have enough information yet?
I think probably the latter. I don't think there's enough information yet. I think that, based on my experience and knowledge with the subchapter 5 trustees currently, they're feeling their way through the process as well. I honestly don't get the sense that they've gotten a lot of guidance from the U.S. trustee on exactly what their role is. And I think that, so all parties are kind of learning that. And, as far as the reporting requirements being onerous, I think that it depends on the case, obviously, but I think those at least from my old speaking for the U.S. trustee, they would certainly tell you that they only are as onerous as they are required to be by the code and the rules to protect everyone's interests. But I think there's a meeting point, and I think both Judge Bohm and Judge Doler have indicated that that subchapter 5 has got to find that vein of between the administrative side of it and making money and trying to make the case push through. So I think they've got a challenge in front of them. And that's why I think that role and that person that is selected for the trustee is very critical to the success of the case.
Well, let me say that I agree totally with Judge Bissett. I think it's important to note that they're taking a risk, these trustees right now, and how are they going to charge? But, I was a trustee for 35 years, and you took some cases, you got burnt, and some you made it. You lost money totally in Chapter 7 work, usually, because you had to do so much administrative and reporting on top of investigative work, your hourly rate was a nominal amount. But you took the case because there would be another bigger case, another matter that would come in. I think that the biggest problem I see in subchapter 5 is the misleading thought that the trustee is going to be doing almost the duty of a creditors committee, the investigation, the objecting, all that. That's not going to happen. And therefore, it's not like a chapter 11 trustee where they have a duty, they take over. Yes, you don't want that chapter 11 trustee to take over your business if you're a debtor. On the other hand, you've got somebody that's investigating, controlling, taking care of the assets totally. It's a touchy hybrid as I see it. And I think it's going to be hard for those trustees to take control of the cases and really try to mediate it. But I look at our panel and it's a very strong, very highly professional, experienced panel. So I'm very hopeful they're going to be able to really come through with helping them negotiate consensual plans, which is the idea here.
And just for clarification, I believe that the subchapter 5 ceiling now in terms of your indebtedness is $7.5 million. I probably have somebody on the judges would.
Yes. And one
on
more
that.
thing
So,
I want to point out, we have now, we had a committee that was put together by Judge Agresti, and they have put together a proposed form plan to be used in subchapter 5, and we're in the process of reviewing that. So hopefully that'll help also move it along if you can get a plan put together.
okay, that'll create a framework for the trustees in these cases to kind of mediate towards, as Judge Bissett was saying. Okay. Well, this isn't like doing it live at the Duquesne Club because the audience is, either asleep. I've kind of said you can get, your CPE credits, but you have to at least ask a question. So we did manage to get one question from Joel Walker regarding his feelings on why there have been fewer filings. And it has to do with the PPP money availability and the fact that the banks, for public relations reasons, have continued to be judicious in terms of what they are causing their clients and borrowers to do. So, Joel, thank you for that question. At least we know we've got one person that's actually participating and listening. There's probably a few more, but I can't insult everybody when I don't do it in person. A couple other things that I've seen from reading in terms of 2021 kinds of things. I'm always interested as both a person that steps in, primarily with debtors, but occasionally with creditors, is the whole concept of the key employee retention program. There seems to be an increasing focus on trying to limit the economic impact of the CURP kinds of monies. And there continues to be, some degree, particularly in what we see here in Western Pennsylvania with some of our union workforces who feel like they should be getting more protection in conjunction with a bankruptcy filing, in terms of their standing relative to making these companies work long-term. I don't know if that's anything anybody wants to dabble into or touch at this point. I don't think it's anything case specific, but I wanted to kind of, lay it out there as another, item for discussion amongst the judges. Huh.
So what's the question there, Jack? Is it?
Do you see that? Do you see that as an issue in the future?
Well, key employee it's like beauty. It's in the eye of the beholder. And certainly I could see an argument. We've seen it in the pandemic, right? Your employee stocking the shelves at Walmart. If they weren't stocking the shelves at Walmart, how can you get product, there for the consumers? And right. So the importance of those workers has been highlighted during the pandemic. And in fact, an issue, we are now November 5th and we think the election is almost over, right? But it's been an issue in the election. So I can see, it being an issue. We have not had that issue brought before us, but I certainly can see it.
Judge Tedonio has joined us. Judge, welcome.
Thank you. Hello, everyone. Sorry I'm late.
We haven't said anything good or bad about you thus far, so now we can start.
All right, very good. I appreciate it.
All right. We just, the topic on the table was related to my hypothesis that there's increasing pressure to reduce the impact, economic impact of key employee retention plans and the dollar impact that that causes in some of the cases, and the belief that, the other key employees, the union employees and the other people who are helping make the business work are just as important and should be given, more consideration in the bankruptcy process. I don't know, again, I'm catching you a little off guard because you just joined us, but if you'd care to offer any thoughts on that or anything else, because
Judge Tedonio is always ready. He's ready.
And you now have the floor, Judge. So anything else you want to comment on? Open forum.
Yeah, I mean, I don't know that I have any specific thoughts on that because, well, first off, I mean, we've not had a lot of those issues come up in our cases here locally. I mean, I know that came up not too long ago. Well, I guess it's been about a year now in Toys R Us and some of these other issues, and whether there'll be additional legislative fixes for that. But certainly, I think that's an evolving issue, and where that goes, I don't know. I think that's the extent that probably I would be willing to comment on that at this point.
In our discussion last week or two, you'd indicated that you had some thoughts on the subchapter 5 and the Small Business Reorganization Act and what was going on locally. Would you care to comment on that while we focus on you for a few minutes?
Okay. Well, did you cover any of that before?
We
Yeah,
did.
we did. We covered it, but I guess he's looking for your comments.
Okay. Well, I just didn't want to have to. I didn't want to double up on anything else that anyone else has talked about, but certainly, the expectation is that that's a new vehicle that will be used by a lot of folks to get these cases in and out of bankruptcy much more swiftly. And certainly there's advantages to doing so, both procedurally and substantively. The other thing that's interesting is obviously with COVID, the debt limit was increased, and there's been talk on Congress that might be more of a permanent increase. That was something that was highly negotiated last year when the subchapter 5 was being implemented. Originally, it was going to be a $10 million level, but then it was reduced. So I think that's going to be the case, and certainly the success that we see now in the cases that are going through the system will certainly help make that a more permanent solution going forward. But it's exciting to see a change like that in the code, which was a rather substantial change, the first one we've really had in about 15 years, and certainly interested in seeing more people explore it and take advantage of it and see if that can help their clients and substantially reduce the cost, because that's one thing that I've always heard from this group is that you don't like the bankruptcy process because there's too much cost and expense and time wasted on it, and Congress has heard your requests and has delivered this, and so willing to move on these cases as quickly as the parties are able to. Hopefully I didn't copy anything else that anyone said on that.
No, appreciate those comments and that feedback. I would suggest that part of the cost of the bankruptcy process, I hear from lenders 10 times out of 10. And conversely, from the bankruptcy attorneys who practice, I've heard it 0 out of 10. So there's a difference of opinion as to how effective the process can be and how effective the resources are and what the cost is relative to the lenders. So that kind of leads me to my last topic of the evening. We have certainly seen over the years a transition from the thought process or the bankruptcy process in terms of plans of reorganization to where most of what we see now are expedited, Chapter 11 assets, 363 asset sale transactions. And I believe that the driver for that, to pick up on your comments, Judge Sidonio, is that the lenders are oftentimes just uncomfortable with how expensive the reorganization process may become. And so they're more inclined to try to get their money and get out. And again, ultimately they carve out something for unsecureds, but at the end of the day, the DIP lender and the banking community is, in my opinion, driving more of the 363 sale process on an expedited basis through the bankruptcy code. Again, open forum for discussion, or does anybody want to comment on any of that? That's a Jack opinion, so. Okay.
I will, Jack, I will agree with you. At least my observation has been in West Virginia that definitely is a more atypical type of Chapter 11, at least lately, has been motions to sell most of the assets on a quick timetable. And obviously that creates issues for all parties, and particularly the need for quick hearings. But I would, if nothing else, agree with at least your statement that seems to be the direction that we've seen in West Virginia to a lot of cases.
Okay.
Jack, isn't the tension really how much the banks are willing to pay for the benefit of the bankruptcy process? I've seen cases where maybe the Chapter 11 is filed not in concert or not in communication with the lender, but then the lender wants to force an immediate sale. And then you have other instances where maybe the borrower and the lender work together and they negotiate a carve out, before they file. And it's those pre-negotiated cases which actually go smooth. It's the free fall cases that don't. And that's probably really the lesson for the lawyers who are doing work on the borrower side, that, it pays to have advanced meetings with, the bank or the bank group, and to have a pre-negotiated plan, because otherwise the cost is arguably too high, because your way through the process and you're fighting over what type of consents you need, or circumstances where you have to go in front of the judge and fight over the extent, nature, and use of the collateral. So.
Well, that's one thing we didn't discuss under subchapter 5. I think the only way they're working is if you've worked something out before. It's moving too fast. If you haven't worked with your creditors beforehand, it's going to be really hard to get everything done in that short period of time. So these subchapter 5s that are going to be coming in probably will have negotiated something with their creditor, their secured creditor, before they get filed.
Well, we'll have to continue to wait and see how that plays out as that unfolds. And again, I'm not sure, to what extent the lender community is, well versed enough with these subchapter 5 cases yet to see what the impact is on the secured creditors. But I think that will, come more into focus as we turn the corner into 2021.
Well, but it goes to your comment, Jack, that if what the lender is worried about is the cost, they should like a subchapter 5 because it's supposed to move fast. The cost should be a lot less. You could have pre-negotiated a lot of the terms. Maybe you're not done with all the moves you're going to make in the plan, but you've got a substantial idea of the terms you're going to put forward. So it may be that the secured creditors may look favorably at it.
Plus, you have the benefit of a trustee in the case monitoring for any bleed of the assets in the case. So I agree with that.
Well, all that sounds like, positive direction. And again, at a $7.5 million kind of threshold, there ought to be some perhaps more meaningful kinds of businesses that are able to take advantage, of the subchapter 5 process.
Yeah.
Jack, let me ask you this question. You're a turnaround guy, and with there being the subchapter 5 trustees who act as a dispersing agent, in these subchapter 5 cases, does that Does that give you more comfort when you're involved in these cases, especially if you're retained by, you know, if you're retained by the lender? I mean, does that give you an additional comfort to relay back to your client that there are these checks and balances in the case, and accountability and monitoring of funds and those types of things? Does that help?
Absolutely, Judge, absolutely. Because again, in a lot of the small businesses, control of the checkbook is, my words, somewhat random. I mean, there's, you know, several people, all of whom are authorized to write checks. And before you know it, they are all writing checks. And the dilemma is, at the end of the month, when there's not enough money, they sit down and say, well, I didn't know you were writing these checks to these guys, and I wrote checks to those guys. So I think the control element in the involvement of an outside, you know, trustee to monitor that process is a additional comfort level, you know, to the lender community, and I would think to the creditor community as a whole. Closing comments from anyone? Otherwise, we'll wrap this up, and I'm going to have to go get a drink as well. Judge Deller, any other comments for the group?
No, the only comment is gosh, I miss the real live event. I have my beverage here, non-alcoholic, but you know, my beverage nonetheless. Please, if we have Zoom hearings though, please no drinking, no eating hoagies and smoking during the middle of a trial, please. But you know, we'll be back to normal someday.
All right. Judge Bohm?
Yeah, you know, it's been very easy for me to be chief judge with the bar, being so cooperative with everything. So I want to thank everybody that's on the Zoom call, and they know it. I've repeatedly thanked them for being so amicable with our staffs and with the clerk, and trying to work the case as well. That's why everything's moving along. We're all ready to, you know, if we get a huge influx, everybody's caught up in the work so that we can handle it all. And so thank you. And I'm
Okay.
looking forward to getting together too.
Judge Sidonio, you weren't here long, but closing comments?
Well, I think it's going to be an interesting time for all of us, coming up very quickly, not only from volume of work, but also the likelihood, depending on what these final election results are, of whether or not there's going to be further changes in the bankruptcy legislation. But certainly missed the opportunity to see everybody in person, and thank you for the opportunity to be with you here. And just to add to Judge Deller's comments on the Zoom hearings, please also do not flush your toilets during the
Do those constitute new local rules, by the way?
Yes, that is part of the administrative order that's being handed down.
All right. Judge Bissett, closing comments, thoughts?
The comments again. I thank you for the invitation, and it was truly a pleasure to see my fellow judges' faces and have the opportunity to at least meet them that way. And I thank everyone again for the invitation.
Well, again, special thank you to you folks for, you know, continuing to be interested in doing this, you know, for the benefit of the TMA membership. We very much appreciate it. I specifically look forward to doing it in November of 2021 at the Duquesne Club in person, and perhaps we spend 2.5 hours socializing and 20 minutes doing a program in 2021. Thanks to all the TMA sponsors. I'm not sure that there's any further announcements on a TMA holiday party that's going to take place in December. They may try to do some type of a Zoom party. I'm not sure how well that will go over, but I do think they're going to do some kind of, you know, fundraising event, because the people that we put the program together for and the donations we make at the annual holiday party are still an important component of, you know, what's important to this membership. With that, let's just close. Enjoy the rest of the November, to some degree, chaos, and have a good Thanksgiving holiday, and look forward to seeing some people at some point down the road. So thank you all, and that concludes this evening's program.
Thank you, Jack.
Bye,
Take
everyone.
care.
Thank you very much.